Former President Donald Trump is facing 4 criminal trials, and they are on a collision course with his 2024 campaign schedule. Take, for instance, his trial for the alleged election interference, tentatively set for March 4th, just one day ahead of Super Tuesday, where voters in more than a dozen states and territories head to the polls. Meanwhile, Trump is also expected to appeal any day now, could be any moment, that ruling by Colorado's Supreme Court that kicked him off the state's ballot. On Christmas Eve, Trump took to Truth Social to write in part that almost everyone agrees, even the most crazed radical left lunatics, that the Colorado decision is political delusion, and that I am separately fully entitled to presidential immunity, without which crooked Joe Biden, whose deranged prosecutor Jack Smith is merely serving his boss's wishes, would be prosecuted for destroying our country. End quote. And the day before, December 23rd, Trump's lawyers submitted a filing to the D.C. Circuit Court of Appeals. This is regarding Trump's 2020 presidential election. It reads in part, quote, during the 234 years from 1789 to 2023, no current or former president had ever been criminally prosecuted for official acts. That unbroken tradition died this year. The filing goes on to read, quote, President Trump has absolute immunity from prosecution for his official acts as president. The indictment alleges only official acts, so it must be dismissed. End of quote. A lot on the line. Let's bring in Vice President and General Counsel of Gray Analytics, as well as former U.S. Attorney for the Northern District of Alabama. Jay Town joins me right now. Jay, good to see you. Welcome in.
Hey, Bianca, and happy holidays to you and your family and everybody at Newsmax.
Thank you so much, Jay. Well, it's a busy holiday season, especially if you are a lawyer working for former President Donald Trump. So let's get into it. Are they going to be able to pull this off, both the appeal in the Colorado state primary, also the 2020 case as well? It is seeming that it will be the Supreme Court who will be also very busy. So much on the line here.
Yeah, no, you're absolutely right, Bianca. I mean, you think about it, you have as you mentioned, the Colorado Supreme Court. That'll be a direct filing to the United States Supreme Court. You have cases that are working their way through the D.C. Circuit Court of Appeals. You never know what might come up in the Mar-a-Lago case, which is in South Florida, and that would obviously there would be an interlocutory or pretrial appeal in that case as well. There are issues with the Fulton County, Georgia case as far as the removal statute goes. And there's these arguments really are fascinating, and they're fascinating maybe just to lawyers, but nonetheless, because they've never been ruled upon before. The impeachment clause, right, and then coupling that with the double jeopardy clause of the Fifth Amendment. It's very interesting stuff, and it'll be interesting to see how busy the Supreme Court really is and where they land, because it will be critical to these prosecutions. It could gut them completely or allow them all to go on.
Right, because if they rule immunity, I mean, the case could be dismissed just like that. When we were speaking earlier, you said you believe it's the Mar-a-Lago case that could be the most problematic when it comes to a defense there. Why is that, Jay?
Well, so these other cases, the Fulton County, the Manhattan DA, those aren't serious prosecutors and those aren't serious prosecutions. Jack Smith's a serious prosecutor, but this fake elector theory really is sort of stretching the boundaries of federal law. But when you look to the Mar-a-Lago case, which was the original case, and we all remember, seeing those blue windbreakers going in and out of Mar-a-Lago. He's been charged it's very cunning the way he's been charged. He wasn't charged with classified information possession. He was charged with possessing documents relating to national defense, meaning all they have to do is have a DOD letterhead, and there's sort of a strict liability to those 21 charges, and then the remaining charges he has regard obstruction of justice and the like. So those are very serious charges, and honestly, I don't know why Jack Smith is pushing this January 6th or this fake electors cases, because the Mar-a-Lago case is the easiest for him to prove. Sure, there are some constitutional issues still yet to be decided there regarding attorney-client privilege, presidential or executive privilege, but I would be working through those before I started demanding the court decide upon this immunity issue in the fake elector case.
I guess maybe he thought the Supreme Court would weigh in, which he got denied on Friday. So maybe that was part of the thrust or the focus there. I just have about 30 seconds left, Jay, but I do want to ask you, obviously, when we're looking at the timing of this, we talked about how it coincides with the campaign trail, Super Tuesday and whatnot. But if these are Supreme Court decisions that they take on and they have to weigh this, what do you think the progress will be? I mean, is there a chance that we would see any of these go to trial before the November elections, or could they actually be delayed by Trump's legal team, that none of this would actually come before the election?
Well, that's certainly the strategy, Bianca, and really all Trump's legal team has to do is delay this to about July, because it is DOJ policy not to interfere with elections with things like trials. All these trials would take 4 to 6 to 8 weeks, plus the sentencing. All of that would impact the election in 24. So they would probably have to push it all until after the November election if Trump's the nominee.
Let's see where it goes. I'm sure July is one of the notes they have scheduled and circled on their calendars. A lot of dates circled, I'm sure. J-Town, always a pleasure.
Thanks, Bianca.
Thank you. Well, on Christmas Eve, the New York Times published this opinion